A fancy background. You really can see right into my office, which, as you can see, is dragon friendly. So yeah, welcome everyone to this presentation of the legal working group of AI4People. As you've seen from the announcement, we were one of the three groups who didn't manage to have a totally agreed and final version on the table yet. And hopefully, as part of my introduction, you will also understand why. And hopefully, you will also be able to give us in the Q&A some feedback on how we can improve on these results. But before I move to that, just a little bit of housekeeping. I'm Burkhard Schafer. I was the chairperson of the legal ethics working group of AI4People. And I was assisted in the work by Jacob Slosser, who is also here with us today. And the other working group members were Ronan Kennedy from the University of Galway, Mireille Hildebrand, and at that point, my brain, of course, totally refuses to work with me any longer, which was exactly what I had anticipated. That was essentially our working group. Today we are Jamie Baker and Elisabeth Staudecker. Lots of apologies to both of them. My brain just stopped working here for a moment. And we have tried over the last year to extract and to specify some of the ethical principles that we had in previous reiterations generated for AI4People, with a specific focus on the legal services industry. And I'm joined today on my panel also by external members who hopefully will be able to give us some valuable feedback and get our discussion going. One of them is Gry Hasselbalch, the co-founder of the data ethics think tank, who has for over a decade worked with industry, policymakers, NGOs, and end users across the field of tech, ethics, human rights, and society. She's an independent advisor and has been tasked by international institutions and governments on multiple occasions as an independent expert. Most recently, she was appointed member of the European Commission's high-level expert group on AI, developing ethics guidelines and recommendations for the EU, and is a member of the first Danish expert group on data ethics appointed by the Danish government. Just as an aside, the recommendations of the European Commission high-level expert group heavily influenced and framed the work that we have been doing as part of this project. She's also vice chair of P7006 standard within the IEEE's Global Initiative for Ethical Considerations in AI and Autonomous Systems. Gry is behind several studies, reports, and articles on the power and ethics of data and AI, including the book Data Ethics, The New Competitive Advantage. Jacob, I already mentioned, he was another member of the working group. He is the Carlsberg postdoctoral research fellow at ICORTS, the Danish National Research Foundation Center of Excellence for International Courts at the University of Copenhagen Law Faculty. And his research focuses on the use of cognitive science to understand conceptual change in international law and the use of artificial intelligence in law. This focus is also reflected in his published work and lectures on areas such as the regulation of artificial intelligence in public administrative law, experimental and empirical approaches to legal linguistics, the force of precedent at the European Court of Human Rights, law and gender, and feminist legal theory. Jacob completed his PhD at the University of Kent, Brussels School of International Studies, where he developed a proof of methods for efficacy of analyzing legal concepts through the use of cognitive linguistics, and a truly excellent PhD it was, and I speak as an insider here. And finally, we are joined by Sophia Adams-Bhatti, the head of strategy and policy at Wavelength. She's a public policy expert with 20 years experience working across a number of sectors, including law, financial services, competition, consumer affairs, healthcare, and immigration and asylum. She's currently the head of strategy and policy at Siemens Simmons wavelengths, where she leads on the intersection of law, technology, and policy. But previously, she was Director of Policy at the Law Society of England and Wales. That is our southern colleagues, if I may say so, as a sometimes member of the Law Society of Scotland, where she led, amongst other things, all law reform programs at the Law Society's groundbreaking work on the use of AI in the criminal justice system. A splendid report she developed there, and I had the honor and privilege to be present when it was presented to the government. So exactly the right type of expertise I was hoping to have here. And Wendy has joined us. Sorry, Wendy, you are on my list. I was just, when I started reading this, not sure if you had managed to join us. Dame Wendy Hall is a Regis Professor of Computer Science and Associate Vice President, International Engagement, and an Executive Director of the Web Science Institute at the University of Southampton. She was President of the ACM, President of BCS, Senior Vice President of the Royal Academy of Engineering, and has been a member of the UK Prime Minister's Council for Science and Technology, the Global Commission on Internet Governance, and the World Economic Forum's Global Future Council. She was the co-chair of the UK government's AI review and is the UK's first skills champion for AI. And in May 2020, so very recently, appointed a chair of the Ada Lovelace Institute as well. Thanks a lot, Wendy, as well, for joining us today. Okay, at this point, I have to play with the technology. And if I learned one thing over the last couple of months, then how risky it is to using this technology. But essentially, the idea is I'm going to give you a short 20-minute summary of some of the main findings that we had, but also some of the difficulties we encountered when trying to come up with these ethical principles. And then hopefully, after that, our other panelists will make short statements, identifying hopefully some of the strengths and weaknesses of what we did before we then leave open the discussion to everyone. So let me see if I manage to share my screen with you.
I'm going to turn my video off, folks, while we listen to Burkhard.
Nope. That was not what I had in mind. I knew that was going to be more tricky than I hoped I would be. Share screen. Now we hopefully get it. Okay. Yes, the ethics framework for legal technology in a nutshell. I want to start with a standard disclaimer that was really important for us as we worked on this. It's really important to realize that we do not consider ethics as a replacement for regulation. Regulation comes first. Ethics comes after you are compliant. It's the aspirational part where you aim for excellence, but compliance with relevant legal requirements is non-negotiable. And that includes data protection law. So I'm not going to talk at all about the requirements that the GDPR, for instance, imposes on anyone who wants to develop legal tech. But I'm also not going to talk a lot about such duties as the fairness duty in laws such as the public sector equality duty under the Equality Act in the UK. So here we have hard legal requirements that ensure that the public sector, when using technology, when making any type of decisions, is bound to observe equality duties, and compliance with them is simply not mandatory, and ethic frameworks should not be used to weaken that hard and binding legal requirement. So ethics starts where compliance has been achieved, and I think that is always important to remember. There is a danger that ethics is used as a strategic tool to avoid responsibilities, and nothing could be further from our mind. The second thing to point out is that ethics for legal AI complements but does not replace the general ethical framework for AI. We already heard about the high-level expert groups framework for ethical AI, And we very much see our rules as supplementing and specifying these requirements, but not replacing them. So that allows me to not talk about some of the elements that I think every competent and ethically responsible AI development should take into account, and focus on those that are really pertinent to the legal system. And just one linguistic qualifier. Our working group obviously had speakers, native speakers from English and other languages as well. And there's a particularity of English that I don't think you would find in German. It can create ambiguities if we have a modifier in front of a noun. And that means legal technology or legal AI can mean two things. It can mean that is technology that is actually legal, as opposed to illegal, or it can be technology that is used in the legal services industry. And I just wanted to make totally sure that if we talk about legal technology, legal AI, or ethical AI, we are not making a judgment about the quality of the technology. We are just talking about where it is going to be used. Having said that, we tried to find a good balance between inclusivity and focus. There are lots of technologies that are used by lawyers, by legal professionals, by law firms that are pretty much the same across services industries. Billing, word processing, if you like. Quite a lot of technologies that are generic and also used by lawyers. And we try to exclude these as much as this is possible, and focus our analysis of those technologies that in one way or the other try to replicate a task that previously was only carried out by legal professionals. Well, that was pretty much for us the guiding principles. If that is a task that in the past you would have to have a lawyer present, then it becomes within the remit of our analysis. Law is special, and that is one of the things we found out. Drafting ethical guidelines for law, I think, is very different from pretty much all the other expert groups that AI4People organized for this task. For better or worse, law permeates pretty much all aspects of social life. We sometimes in legal theory call that the process of juridification. It's a pretty much modern development. We rely on the law to sort out pretty much all the conflict that we face in our life. We've enshrined legal rules in pretty much everything that the state is doing. So pretty much all aspects of our life in one form or the other are affected by law. And with that, legal technology also potentially affects all aspects of our life. And as a result, we have a potentially massive heterogeneous spread, both of use cases and also of technologies when we are talking about legal tech. Legal technologies can be relatively simple rule-based systems where a chatbot gives you advice on how to complain about a parking ticket. It can be a machine learning algorithm that enables a lawyer to predict the likelihood of winning or losing a case and basing their strategy on it. It can be a legal ontology that allows lawyers in an international private law conflict to automatically translate a document. It can be information retrieval using the tools of Bayesian statistics, for instance. All of these we try to cover, but obviously they do very often pose significantly different ethical issues. A established commercial player using a lawyer who's assisted in drafting a commercial contract by using AI obviously poses significant different ethical questions from a indigent claimant who can't afford legal representation, potentially comes from an educationally underprivileged background, for the first time interacts with the law, and now has to rely on an automated decision system that tells them that their application for Social Security was revoked. Very obviously, massively different ethical issues that are raised here. And our principles try as much as it's possible to cover all these applications, but obviously they will be more important for some rather than the other. And then finally, law is also different from many other applications because we are in a regulated profession. We have national bodies that act also as disciplinary entities. Things like the Law Society of Scotland, slightly different, the Law Society of England and Wales, but professional organizations that impose specific duties on their members. And that is where ethics gets teeth, and where I have to revoke to a certain extent what I said at the beginning, that ethical principles only ever supplement the law but do not replace it. For regulated profession, that is slightly more complicated, because as lawyers, as practicing lawyers, we are also bound by the codes of ethics that our professional organizations have. So there is a type of ethics violation that can lead to disbarment, that can lead to sanctions. So here we have a sort of middle ground of an ethics that looks a little bit like law without entirely being law. And we try to take that into account in our analysis as well. So these were some of the preliminary arguments and also some of the reasons why we found that establishing these principles was rather more complex than we had anticipated. Partly the spread of technologies, partly the difference in applications, but also the rather unusual situation that some uses will be governed by the codes of ethics of the legal professions and others are not. For framing the talk, I want to go quickly back in history because I think we can learn from some of these past discussions, and some of the past insights that we had have been lost in intervening years. The idea of using AI in the justice system is not entirely new, even though it is generating headlines at the moment. Research in that field go back to the 1980s, 1990s, and one of the first practical application enshrined in law was in 1998, the Social Security Act in the UK, which for the first time allowed fully automated decision-making for social security decisions. It was a rule-based system, good old-fashioned AI, but it incorporated essentially the text of the Social Security Act. And if a claimant came and made an application, it would reason about the applicable law when making its decision. The reasons given in Parliament why that was a good idea to have fully automated decisions are the same reasons that we find today. The argument was this is considerably faster. We have a massive backlog in cases. People have to wait too long to get an answer, too long to get payment. It's cheaper. Society benefits because we are able to deliver the same service at lower costs. And also it is fairer to the applicant. And because it is a cold, rational, logical system that decides about their case, something like the personal preferences of a social worker do not play a role any longer. Some subconscious judgment about merits or demerits do not play a role any longer. Only the numbers, only the facts. So these were the arguments that were presented at the time why having such a system is not just convenience, but ethically mandatory. It addresses social problems. It addresses the issue of unfair decision-making by real humans. It addresses the problem that we underinvest in the social justice system and that therefore poorer applicants are left without timely adjudication. So these are sound and important ethical claims that are made here. And that is just important because I think our principles sound a little bit like the wagging finger of ethics. Don't do these things. And to a certain extent they do. But it is important to remember that sometimes not using a technology can be an ethical failure just as much as using an inappropriate technology. And these are the arguments that you find frequently in the discussion mentioned, why using these technologies is a good thing. However, if you look at the debate in Parliament, some parliamentarians were rather acute in identifying issues with that and concerns. There was a very frank debate. And the first set of problems, and I think all of these problems are with us still today. Now, the first set of problems was simply, how do we know that these answers are correct? Who evaluates them? How do we know that the system performs as anticipated? And where it doesn't do, where a claimant feels he or she was hard done by, how can they contest the decision? What are the avenues to challenge the AI? And also, what are the remedies if they fail? It's one thing to be told, yes, you're absolutely right, the AI screwed up, I'm sorry. It's a very different thing to have appropriate remedies that set you right. Now, even assuming that the decisions are provably correct, even if we can firmly establish that they at least outperform a human decision maker in their correctness, maybe even 100% correct, how can they be explained to the claimant in a meaningful way, and indeed to wider society? And that is, again, I think one of the things where law is different. Explanation in law is not just instrumentally important. It's not just a good tool. It's not just helping you to challenge a wrong decision. Explanation in law fulfills a wider social function. It tells society what the law is. We have public trials because it reaffirms the commitment of society to the law. It clarifies the law. It has an educational function, also to wider society, but also to the claimant. I need to understand, ideally, why I'm facing a specific sanction. I should be able to understand the reasoning as a requirement of justice. So explanations play a different role, I think, in the legal field from many other applications of AI. And they are not just explanations to the subject of a decision, there are explanations that have to be valid and hold to wider society as an observer. And even if we assume that these decisions are correct and can be explained somehow, it could still be that treating people like that is inappropriate for a government, that it alienates them, that it tells the most vulnerable in society that we don't even have time to give them a human to speak to. Especially if in the Social Security Act that was limited to decision-making for the poorest, and not, for instance, automated decision-making for a tax rebate for Amazon. No one was suggesting that, but it was Social Security that was picked out here as decision-making. Doesn't the state send a message here that it doesn't care any longer, that people are not any longer fully citizens in a meaningful way? And parliamentarians picked up on that and said, look, correctness is one thing, but here something else is at stake. How we treat others humanely and how the state interact with citizens. So these three types of clusters of questions, they are the ones that we also hope to establish in our principles: correctness, communication, and the wider values that we cherish in a society under the rule of law. So now I'm going to tell you a little bit about the principles in the remaining time, focusing on some of those that I find particularly interesting. We identified 20 principles, and there might be even more before we are finished. I won't have time to go in any detail through all of them, but I already mentioned that there is a specific role of legal professions. Now, as a regulated professions, we have duties that go above and beyond what we expect of other citizens. And it is really important that these duties are not diluted by the introduction of technology. So that's why we introduce a principle of ultimate responsibility. If a professional lawyer is using technology, that is a professional judgment. And that judgment is subject to all the ethical scrutiny that any other form of professional judgment is subject to. You can't just say, my vendor said it was a good idea, or I bought this and I think everything is going to be all right. These are professional judgments. And also, if you look at European law, European Union law, and how it defines a profession, setting your own ethical standards and adhering to them is one of the defining elements of being in a profession. Being in a profession, however, also means something else. It means a degree of collective responsibility. You are not just responsible to your client as a lawyer, you are also responsible to the justice system. You are also sometimes an officer of the court. The responsibilities you have go above and beyond what you owe any individual client. And therefore, we think there are specific duties here of collective responsibility when it comes to technology. And one specific one here on the screen, it essentially says that if there are problems, if there are issues here, then these need to be shared in a secure way, in a confidential way if needs be, but the law societies, the regulatory bodies have here a specific duty to enable the profession collectively to respond to problems. We see that in medicine. A medical doctor, another regulated profession, is not beholden to the pharmaceutical industry. They are beholden to the patient and to the health system, and therefore if there is an adverse reaction to a drug, there are methods of sharing that information. And we think the same ethical and legal obligation should indeed exist for the professions here, coordinating the response, because as lawyers we are jointly responsible for the well-being of the legal system, and that means sometimes acting against our own interests and sharing shortcomings, sharing problems, so that others might learn from this. A principle of non-avoidance is the second principle, which tells you there is another one, and I'm not going through the system the way our document has it at the moment. just a slightly different grouping. Again, that reaffirms that merely choosing a technological solution does not absolve you from all the other ethical standards that we request of a lawyer. That includes those set up by the International Bar Association, according independence, honesty, integrity, avoiding conflicts of interest. The mere fact that a technology is used does not change that. And finally, the principle of technological neutrality that simply extends that principle to all sectors where legal technology is used. If behavior is unethical if done by a human, then it remains unethical if done by a human assisted by a technology. Those of you who are IT lawyers will recognize where this principle comes from. It's a principle of technological neutrality for the internet. If something is illegal offline, it remains illegal online. If it is unethical offline, it remains unethical online. That essentially incorporates the same idea. The mere fact that technology acts as an intermediary here doesn't change it. So these were principles that we target specifically at the legal profession and their organizing bodies. But they are obviously only one body, only one organization that plays an important role. Public sector, the judiciary are also users of legal technology. And it's here where there's a third part of what I described above, I think becomes particularly important. Law is constitutive for our society. It's not just something we do, but something that plays a role for our collective identity. We understand our society, our country, as being a democracy under the rule of law. And that is important for us. That becomes part of what we are. It is imbued with meaning and symbolic meaning as well. So where I grew up, for instance, that picture there below, that was a type of story you would tell a little child. That is the famous conflict between King Frederick the Great and the miller of Versailles, the miller of Sanssouci, the castle that he had built. The king was annoyed about the noise that the mill was making and therefore ordered his soldiers to simply burn it down. And the miller said, "This is my mill. And as long as there are courts and there's justice in this country, not even the king can deprive me of it." And he won. The king had to back down. And that's a sort of founding element that we still tell ourselves about what it means to be in a society under the rule of law. Our Supreme Court judges in the UK above, the slightly silly dress that they have, that matters. Law is a somber affair. Fates of people are at stake. And it's that imbuement of social meaning where we have to be really, really, really careful when we are using technology. And an ethos of moving fast and break things is a really bad idea when you are dealing with a legal system that has grown over centuries and embodies quite a number of values that have grown and evolved over time. So we have to be careful what we are doing to that specific ethos of the law. And with that, we get, I think, our most high level ethical principles. And that is essentially respect for the rule of law and the integrity of the legal system. Legal technology must respect the integrity of the legal system, must adhere to the ethics, the normative judgments that are inscribed within. And that means every legal technology should have a rule of law impact assessment that asks essentially the null question. What problem do you intend to solve? What problem do you not solve? Be upfront about this, be honest about it. What can you not solve? And what new problems do you actually create through that technology? So for instance, using again the Social Security app as an example, at the moment, lots of people do not have access for fast and inexpensive legal advice. Technology can obviously help here. That is a certain problem that it solves. But what it doesn't solve is the problem of notorious underfunding of the justice system. And quite on the contrary, it might create new problems because it enables politicians to squeeze even further the legal aid budget by pointing at technology that will somehow sort of our problems. So these are the questions every responsible legal technology development has to ask itself. Be honest with yourself. What do you want to solve? What will you not solve? And think about the long term, the issues that can be created. And that brings me to the two problems that for me are for us were in a way the most important. First of all, the rule of law, the concept of illegality transcends a binary relation between individual and the state or lawyer and a client, constitutes a common good, and that means evaluation of ethical risks for the deployment of technology must therefore consider long-term detrimental impact on the parties and the common good of living lawfully. So it's not just an ethical issue of how you treat your client. It's not just a question of how does the state treat an individual claimant. But the ethical concerns in legal technology go beyond that. I'll give you a very quick example for that. Imagine you have a tool that can reasonably accurately predict the outcome of complex criminal cases. That sounds interesting. Imagine you're using that to decide which cases to take on, because otherwise you are wasting the money of your client. You raise unrealistic hopes. You are really using it for one of the key tasks that you as a lawyer have to fulfill. Tell your client if necessary, you have no chance in hell. Don't waste your money on that. You will lose, and your client wants to hear that. Now assume that technology works actually reasonably accurate. It seems to be a winner. It helps a real need. It prevents people from overextending themselves, from having unrealistic hopes. Nothing can go wrong, we might think. But one of the long-term consequences might be that now certain types of edge cases are not litigated any longer. Every lawyer is going to use that tool. It works so brilliantly. The algorithm will always tell you a specific type of case scenarios won't be successful. Don't do it. And as a result, people don't do it. And that means potentially that our legal system ossifies, because our legal system also evolves because sometimes people take a long shot. Sometimes people take a risk, and that can sometimes, if it happens in the right moment, have tremendous impact. If you had asked at the evening one of the most important Scottish decision on marital rape, if you had asked at the evening, how will the court decide? Everyone would have said, you have no chance. It's a well-established practice under Scots law. It's not competent to charge a husband for the rape of his wife. There were books written on that. There was authority on that. There was case law on it. Every lawyer would have said no. The AI would certainly not have said no. But one person was willing to take the chance and say, let's see if we can make an argument that will allow the judges to change their mind and bring our law in the 21st century. Stallard, against Stallard. And they were successful. One of the most tremendously impactful decisions in Scots criminal law happened against the odds. So one negative consequence of a tool that is really good for client and lawyer in the individual circumstances might still have detrimental consequences for the legal system. It might ossify it, deprive it of the oxygen it needs to breathe. So that's what we mean with a transversal impact assessment. The ethical risks of legal technology go beyond what happens between client and the lawyer and have to take into account wider societal interests. I'm flicking through some of these principles now more quickly because we won't have lots of time, but legal technology is shaped in context with significant power differentials. And that is the other important thing for us. Citizen against state, the lone consumer against the big corporation, those with expensive lawyers and those without. Responsible development and deployment of legal AI must be aware of these structural conditions and protect against unfair redistribution of risk and benefits. Every technology has its risks. That alone is not a reason not to do it. The ethical question is, where do these risks end up? Do they end up with those that already can't afford them, that are already the most marginalized, or does it end up with those who can protect themselves against it? So most ambitiously, AI in law should aim to reduce existing power imbalances and reshift the risk away from those that can least afford them to those that are best placed to afford them. Very quickly, a couple of other principles, the ones that are particularly close to my heart. One danger that we have when we deploy AI in the justice system is that decisions are taken by software designers that in the past would have been part of a deliberative political and democratic process. And they also could have been changed through that very same process. If you don't like the laws, you can change them. There are mechanisms for changing them. One of the ethical risks of legal technology is that this participation becomes sidelined, that decisions of interpretation of the law, of the deployment of the law, are taken by technologists and not any longer by the politicians who commission these technologies. And secondly, once we have them in place, they are expensive or potentially expensive and difficult to replace. So the idea that parliament can't bind parliament, that people remain sovereign and old laws can be kicked out, that potentially at least can get called into question through technologies that are deeply embedded, hard-baked into our everyday world. So the principle of unfettered participation essentially asked to focus on participatory community-led development of technology to make sure that all the voices that we normally hear in the lawmaking process are also heard when it comes to development of legal technology, and to support people to contribute in that way. We have a couple of other principles that go in the same direction, that essentially say, if you rely on the community to participate, you also should reward the community. You should not simply say, oh, it's absolutely great that you contribute here your experience. No, actually, we benefit from it. Therefore, we have an ethical obligation to make good. That also leads to a principle of diversity and representativeness. Groups and individuals who, through their labor and experience, inform the development, they should be as diverse as a society that they serve. I have to point at least 3 fingers here at our own group. We managed, I think, the balance between male and female quite well. We didn't manage quite as well ethnic representation. We didn't manage at all inclusion of people who are economically or educationally disadvantaged. Advisory boards tend to come from people who are middle class, well-educated and secure in their lives. I think that is a problem. And I can only say mea culpa on that one. But at least you shouldn't do what we did. And if you set up an ethical advisory board, then you should make sure that it is as diverse as the community that it tries to serve. There are a couple of other principles that try to address the issues that we addressed before. What type of explanation do we owe citizens? What type of redress? Think about what will happen if something goes wrong. So these are 20 principles. As I said, I won't be able to work through them, but you've now, I think, hopefully got an idea what our overall concerns were. And why we think these concerns are both more grave and more difficult to trace than the deployment of AI in many other sectors. And what is at stake here is quite tremendous. For us, the most basic foundation of our society as a society under the rule of law. And I think this is particularly important also given that this was a working group that was working in the European context, because the European Union is a massively unusual entity in that respect. It is an entity created through and from laws. And I think my new compatriots, the British, never quite understood that. They always thought of it more as a traditional political entity, where issues are regulated through the power play between political players, rather than at an institution that really says, we will follow the rules. It doesn't matter if they are harmful. And so I think the European Union is particularly pertinent in this emphasis on the rule of law ideal. And that's why we put that at the very heart of our recommendation. Partly because we are concerned for it, because we think technology has a real potential to undermine and disrupt it, but also because, as I said, the non-use of technology prevents us from achieving some of the ideal of justice for all that is also part of the rule of law. So that's been me, slightly longer than anticipated, but these were my thoughts on this. The idea, as I said, once I've regained my breath, was to pass it on. And I'm simply going to do it by the probably totally arbitrary mix of people that my screen gives me. I think at first, if it's okay, Jacob, to you, because you were also a member of the group before we pass it on to the externals.